Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, a supersized version of the Gavel. Our look at immigration in America's courtrooms. We'll dive into the public charge rule, the Remain in Mexico program, and the questions surrounding Ken Cuccinelli. All that's just ahead. Stick around. Hey, before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. As always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hi, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hey, Cris.
Hey, Jordan. How's it going?
Good. All right. In January, the Supreme Court ruled 5-4 on ideological lines to lift a nationwide injunction against the Trump administration's public charge rule, which limits access to visas or green cards for those who may have used government benefits or who the government believes may use those benefits in the future. A second 5-4 decision last month lifted a final injunction against the policy in Illinois. Then, 2 weeks ago, U.S. Citizenship and Immigration Services announced it would begin applying these new rules to all new cases. So, Cris, let's do a quick recap to start of the public charge rule. What is it? Who does it affect?
So the concept of public charge has been a part of immigration law since at least, right before the 1900s. It's been part of our immigration laws. And the idea is that a immigrant who comes to the United States should be able to sustain themselves financially and not rely on public benefits. This concept has evolved over time, but really it was sort of around 1999 that we saw sort of the modern incarnation of the public charge rule, which at the time was largely, is this an individual who's going to be seeking a green card? Maybe a green card visa to come to the United States, or they want to adjust status. They're already here on a visa and they want to get a green card, whether or not they're going to be accessing certain means tested benefits. And that was sort of the extent to it. The Trump administration began developing an update to this rule, at least since 2017. And the new rule does a lot more than the prior incarnation from 1999. One thing is obviously it's still assessing whether or not an individual has used public benefits, and that is something that's going to be assessed. But I think the most important part is that it does a totality of circumstances test, which essentially says, will this individual use public benefits in the future? And the person who's reviewing a green card application, once again, either coming from another country or adjusting here, has to apply this test and see whether or not that's going to be the case. This can include an individual's professional background, their financial statuses, their age. So these are all things that are taken into account. And so it's a pretty extensive rule, and it probably will have a significant impact on permanent migration in the United States.
Theresa, what did the Supreme Court majority say in these two cases in allowing the rule to go into effect?
Sure. So what the Supreme Court did, as you said, was lift preliminary injunctions that had been put in place by lower courts. So it's important to note that the Supreme Court didn't rule on the merits of the underlying case against the public charge rule. They simply said that the rule can go into effect while this underlying case is moving forward. And in general, the Supreme Court, particularly Justice Gorsuch for the majority, really took aim at the idea of nationwide injunctions, and that they were trying to limit the use of nationwide injunctions. The plaintiffs in this case that were suing the federal government argued that a stay of the injunction normally would preserve the status quo, and that the Supreme Court, by allowing this rule to go in place, was actually changing the status quo, and that was abnormal. But again, a majority of the court, 5 justices, did not agree with that. Now, I think that the main issue for the Supreme Court in this case right now was that they did not also believe that the plaintiffs made a strong enough case that the government did not have the authority to go ahead with this rule, especially since it did go through the regular notice and comment period. A couple of the other points of the case they didn't get to. Mostly it surrounded whether or not it was appropriate that the lower courts had issued a nationwide injunction.
This was, as I said, another 5-4 ideologically divided ruling. How did that ideological divide play out in the majority opinion and in any dissents?
Sure. So in the first case, which was about the New York State injunction, the dissenting justices did not issue an opinion. They simply said we would not have granted the stay. But in the second case in Illinois, Justice Sotomayor wrote a pretty strenuous dissent of removing that injunction and basically excoriated the government from rushing to the Supreme Court for every case where there was an injunction without waiting to see what the lower court said. And also took some aim at her colleagues in the majority on the Supreme Court for not really looking into the merits of the case at all and simply saying there's no need for an injunction at this point and taking the government's word for it that somehow the governmental interest would be harmed by leaving the injunction in place. They didn't really examine any of those claims. And so she argued a little bit, not a little bit, a lot, that the process is broken, that the Supreme Court is not taking its duty to examine the government's case strenuously, seriously, and that the government is sort of rushing to them too soon before waiting to see how things play out in the lower courts.
So, Cris, let's turn to where we go from here. What happens next with this policy's implementation?
So, as you said at the beginning, that obviously USCIS is now in the process of implementing the public charge rule. There has been, I think, a lot of uncertainties about the implementation of the rule. Theresa, I think, what was the one thing that was really confusing?
Oh, they're really confusing. So one of the negative circumstances that can be applied in that totality of circumstances test is the fact that you're applying for green card is a negative factor in assessing your eligibility for public charge for getting a green card. So it's sort of a recursive problem. The government's argument here is that since they have to determine whether or not you are ever likely to become a public charge while you're in the United States, and the benefit you're seeking is indefinite leave to live and work in the United States, then they have to look at an indefinite period of time and whether or not you would ever become a public charge. And that in of itself, the longevity is a factor, negative factor. Now, is it a big negative factor? I think, maybe not. But for people on the bubble, that's an issue. And it also is kind of odd.
So that's one example of what you're saying is that there's a lot of, it is a very long, complicated rule. It went through multiple versions and eventually was shrunk down. It's still an extensive, hefty rule that I think that the implementation, I think there's still guidance that's being issued to USCIS officers on how to, deal with this. So yes, the rule is being implemented. I think there will be a lot of kinks that are going to be ironed out. I think if you're an immigration attorney, you've got your work cut out for you because there's going to be a lot of work that they're going to have to do with interpreting the rule and trying to get USCIS to at least clarify some points. So I think that that's really what's going to happen. This is just going to be a lot of clarifications over the next year and what's going to be happening. The rule is the rule, but obviously the agency level guidelines and the instruction manuals for this might be reflecting sort of some streamlining and trying to figure out the kinks.
Yeah, I think, as I said, the underlying court case about this public charge rule is still going forward. So we could have another court ruling. In the meantime, as individuals maybe start getting denied their individual cases, you'll see administrative appeals and, maybe appeals within the administrative system that could set precedents on how those rules are applied. And that in of itself can generate additional federal court cases in individual cases. So the litigation over this is by far from done.
Yeah. So where do those underlying court challenges stand right now on this policy?
So it basically goes back to the federal court in New York that had one of the underlying policies. Another injunction was in the state of Maryland, and another one was a limited one in Illinois. All of those district court cases are still pending and have to go back up through the appeals courts in those districts. So it could be another year before we see resolution of all of the different factors on these cases.
Yeah, and obviously I think we're going to start saying this a lot with the Gavel segments because of the election. it may be the case that a new administration, obviously we're not going to play on which side might win or might not win, but I think if a new administration comes in, there's very much the likelihood that, it may not be pushed forward through the appeal process, or may not be defended before any federal courts. But obviously that's a lot of speculation at this point.
Okay. When we come back, remain in Mexico. Federal courts continue to decide dozens of cases launched against the Trump administration's policies addressing asylum seekers at the U.S.-Mexico border. Late last month, the Ninth Circuit Court of Appeals in California issued an injunction against the Migrant Protection Protocols, better known as the Remain in Mexico policy. The program sends asylum seekers back into Mexico to await their day in immigration court. But that federal court then stayed its own decision that same day at the administration's request so it could file an emergency appeal. In the meantime, many migrants have arrived at the southern border believing they could move forward with their cases, only to discover DHS will continue adhering to the policy until the court battle is resolved. Theresa, what were the arguments made against the MPP, the Migrant Protection Protocols?
Sure. So this is a little bit wonky. The main argument the plaintiffs had is that the Migration Protection Protocols, as implemented by the government, violated the Immigration and Nationality Act. So the details of that are kind of technical, so I'll try to explain. The section of the Immigration and Nationality Act that allows the government to let people remain in contiguous territory while their cases are pending is a particular subsection of law. It's called 1225B2 for arriving immigrants. A different section, a related section just above that, is 1225B1, which is the expedited removal section. Now, expedited removal applies to individuals who arrived to the United States and meet certain criteria of ineligibility to enter. Everyone else is covered under Section B2. And the wonky technical argument here is that the Remain in Mexico policy, the MPP policy, the section of law they're doing that under, only applies to that second group, B2, and not B1, except everybody they're applying it to actually is B1. That's the wonky issue. The bottom line is that the court said in this case that they believe the plaintiffs are likely to win their argument that this program, as it's being implemented, does not meet the law. That's part one. Part two is also that the program, as it's being implemented, does not meet the United States treaty obligations under refugee and asylum conventions that we do something called non-refoulement, which is the French term under international law that means we can't return somebody to a place where they're likely to face harm. And that there's not enough due process in the MPP to ensure that migrants returned to Mexico are not likely to face harm. Those were the two grounds on which the court believed that the plaintiffs were likely to prevail and under which they issued the injunction.
So, as you said, the court showed some sympathy for the plaintiffs' arguments, but then it went ahead and stayed its own decision just a few hours later. Why did they do that?
Well, the government asked, and they said that the government would be harmed by issuing a stay on the program and stopping the program right now. One of the things they argued with support of a letter from the U.S. ambassador to Mexico is that somehow it would harm U.S.-Mexico relations. And the court agreed, at least so far as to allow an emergency stay until subsequent arguments could be made before the court. It's worth noting that this case has already been in and out of injunction in this same court a couple of times already. So there was a motions case that happened earlier, which the government was allowed to proceed with MPP after initial injunction. Then this was a merits case before a panel of judges of the Ninth Circuit that said, nope, we're going to allow the injunction to go in place. They stayed it so that there could be an emergency appeal, probably to another group of the Ninth Circuit. This will eventually get up to the higher levels of government. I'm sure it'll go to the Supreme Court as well. But it's important to note that the government is trying really, really hard to keep MPP in place. They firmly believe that it has been the cornerstone of what has been a sharp decline in the arrival of families and others from Central America at the border claiming asylum. And I think there is significant concern that if it goes away, there will be a new rush to the border.
Cris, as I mentioned in the introduction, there was some confusion after this ruling, migrants showing up at the border wanting to, proceed into the United States and have their court date. What has been the impact at the border so far?
So I think we saw a sneak preview in a way of what potentially could happen if MPP is overturned. Theresa touched on this a little bit, but what you essentially saw, and I think it does reflect how modern communications can impact this, is that at least from what we heard reports, people started getting WhatsApp messages and text messages about the agreement, about the decision, and they started arriving at ports of entry along the U.S.-Mexico border. Some of them actually even holding copies of the ruling in their hands to hand over to CBP. Within hours, I mean, when we say it was stayed, I mean, I think the decision came out around 5:15. It was stayed around 9:30 or 10 o'clock the same day. So people were showing up, people were trying to cross. Then instantly, when the stay went in, CBP said, "You're not crossing, you're not passing, you're not doing anything." And what you started hearing is a lot of people express, at least the migrants in the MPP program, were expressing disappointment about this. So I think that this is going to be very delicate when it comes to this ruling, because as Theresa noted, this has been the core component of the administration's efforts to deter asylum seekers, or at least individuals from arriving to the U.S.-Mexico border to seek asylum. And if this is overturned, I think we're going to be facing a situation where at least people who are in the program kind of want to move forward. It is important to note that there are other programs in place that allow the administration to quickly remove asylum seekers from the border. This includes the asylum cooperative agreements with Guatemala. There's also 2 programs of expedited removal that are called PACER and HARP that apply to asylum seekers from other parts of the world, and also HARP, which is for Mexican nationals. So it's not like they're lacking any tools to try to deter people from arriving in the United States to seek asylum, but this has really been the core of it. And I think if it gets overturned, once again, I'm going to have to start doing this note saying, if, depending on what happens in November, of course, that will, I think, depend a lot on how a future administration will have to respond in the case that this is overturned and how they're going to manage this.
Yeah, so given, and maybe you answered this to a large extent, but given how important MPP is to the administration's border strategy, as you've both said, where do they go from here? How are they going to proceed in the court battle? How are they going to proceed in trying to implement and maintain implementation of this program?
Yeah, with implementation, I think they want continuity of implementation. I think that they want to have a continual implementation, no interruptions. Because if you think about it, it's when there's litigation, obviously CBP from director level straight down to the agents at the border, and that was, they need to implement it. They need to know what's happening at all times. And when you have this whiplash, not only does it impact the migrants, it impacts, CBP staff on the front lines. So they think that they want that continuity.
Yeah, I think, whiplash is the right answer for this. I mean, if you're a frontline CBP officer, you're not following WhatsApp, you're not following Twitter, you're not following these court cases closely. Somebody shows up at the border and says, so the court just ruled that you can't keep me out. This frontline officer is going to immediately look at their supervisor and go, what's this person saying? Are they correct? Did we hear anything from headquarters? They're not going to change their behavior until they hear from the higher ups, regardless of what piece of paper somebody has at the border. And in this case, I think USCIS had started maybe issuing some guidance to their folks about changing how they do things at the border. CBP had not yet. And then, of course, the stay came into it and everything stopped again. But it's that rush to try to figure out how to respond operationally that is hard for an organization as large as the government. I mean, even though the court has made an order and you're supposed to abide by it, it takes time for that to be conveyed, right, through a large organization and what it actually means. So, I mean, I think it's important to understand there are operational implications for these court orders and how they are implemented. And the government does have a case to make, and they do make the case that operational imperatives are important to take note of, that you can't just suddenly turn a switch on and off and have the government respond. That having been said, the court made a pretty strong case that what they are doing is illegal. And if the court upholds that ruling that what they are doing is illegal, operational considerations go out the window. You cannot continue to do something that's illegal, and they will have to stop.
I think this is the common thread in the implementation of immigration policy in the Trump era. And potentially in the future too, even if a Democratic administration comes into power at some time in the future and they're doing things through executive action, this will repeat itself.
Yeah, the continued litigation that affects policies and operations in these kind of chaotic ways. It's no way to run a government. It's no way to run a system. It's not fair to anybody in the system. And I think we need to figure out how we get back to a more regularized way of managing things.
All right, after the break, the saga of Ken Cuccinelli.
Momentum starts with finding consensus. The Bipartisan Policy Center works tirelessly to find common ground, but the effort doesn't stop there. We need you to keep that momentum going. Learn more about how you can support our work by visiting support.bipartisanpolicy.org.
A federal judge in Washington, D.C. recently ruled that Ken Cuccinelli, the acting director of U.S. Citizenship and Immigration Services, was improperly appointed to the position and is thus ineligible to serve. In addition, the judge ruled that 2 policy memos signed by Cuccinelli related to the asylum program were invalid, raising questions about whether Cuccinelli's appointment imperils the administration's policy agenda. So first, let's talk about the acting director appointment. Even getting Cuccinelli into position to be tapped for that role required a fairly convoluted process. Theresa, how did all of this happen, and why did the court say it was unlawful?
Sure. So a couple things to remember is that Ken Cuccinelli has never been confirmed by the Senate to any federal government position. Before he came to be acting USCIS director, he had never served in the federal government whatsoever. So he was coming completely from outside of government. After the resignation of former USCIS Director Francis Cisna, the Trump administration decided they wanted Ken Cuccinelli to lead that agency. However, under the rules of succession that DHS had and something called the Federal Vacancies Reform Act, which is a federal law that governs who can take over positions in government, the person who automatically assumed the directorship, the acting directorship, is the deputy director of USCIS, who at the time was Mark Cummins. In order to insert Cuccinelli, they had to create a new position of principal deputy director. They gave that position to Cuccinelli and then named that position as the first assistant to the director and therefore elevated to acting director. That creation of that position and the change in the line of succession are what were at the core of this particular court case. Now, since that time, we should also note that the secretary and deputy secretary, or the acting secretary and acting deputy secretary of DHS left, and Chad Wolf was named acting secretary, and Mr. Cuccinelli was named acting deputy, and I'm using air quotes there, because the acting title can only be conveyed for a limited period of time, after which you can no longer be considered acting. There's this framework called the senior official performing the duties of whatever the position is. And that's technically what he is right now. He is technically senior official performing the duties of director of USCIS. As well, he has been named senior official performing the duties of the deputy secretary of DHS. He's actually serving in 2 capacities at the same time. That is the level of, I want to say, calisthenics that has been done by this administration to put this person in positions where they wanted him to be.
So you bring up another good angle, which is that DHS leadership is just chock full of folks in acting positions or senior officials performing the duties of people in acting positions, including the acting secretary, Chad Wolf. What could this ruling mean more broadly for acting leadership at DHS?
Yeah, so let me dive into the ruling a little bit more. What the district court judge said was that under the Federal Vacancies Reform Act, this particular appointment, Ken Cuccinelli, violated that law, in part because the law says that only the person who is the first assistant to the principal position can be named into that position. By creating this new position, the way it was created by then acting secretary Kevin McAleenan was to say that this position became the first assistant to the vacant director position, but that this position would only exist so far and until there was a new director named and appointed and confirmed by the Senate. So what that meant was the position that Cuccinelli was named to was a temporary position. The judge said that in spite of the Federal Vacancies Act saying you can have the first assistant move in, this position that was created to him never actually is assistant to anybody, because it was created after the person he was supposed to assist is gone and is going to go away when there is a new person to assist. There is now an infamous footnote in this that leans into a ongoing trope in the office that the assistant to the district manager is not the assistant district manager. And that's the case we're kind of doing this. So the assistant to the director is not the same as the assistant director, or in this case, the deputy director. And it's on that ground that they said that this particular appointment and this particular position were invalid. Now, he immediately invalidated 2 specific asylum policies that had Cuccinelli's name on them. There are lots of other policies that could be implicated. But if this ruling stands, all of these other acting positions where people have been shifted around may have to be reexamined to see how closely they align with the Federal Vacancies Act.
So, Theresa, you mentioned those 2 specific policies that this ruling voided. Cris, could this ruling impact other policy changes that Cuccinelli has ordered? And explain for me just a little bit about what these 2 policies were.
So these are policies that support the administration's efforts. You've been talking about MPP in this episode, but that have been supporting sort of what the administration's been trying to do at the border, which is limiting asylum access to deter individuals from arriving to the southwest border to seek asylum. One of the core ones is what is now known as the transit ban, which is essentially that if a non-citizen traveled through a country and arrived at the U.S.-Mexico border without having applied for asylum there, that they could be denied asylum by USCIS. This has been pretty pivotal because it sort of supports the asylum cooperative agreements that we have with Guatemala, Honduras, and El Salvador, where you get denied asylum and you get hit with a bar against future legal entries, and then under the agreements, then you get sent back to one of these countries. So that, I think, is really the key rule that's been impacted by this ruling. But like, Theresa was saying, is that as you continue moving forward and sort of realizing the implications of this, there are other possibilities that anything that he's sort of has signed off, since then could be potentially impacted. One thing I think is worth noting is that a lot of the more recent regs, though, or at least policies, have been largely either signed off by other past directors, such as the public charge rule. That wasn't really the case. We've talked about, for instance, the executive orders on whether intending immigrants, so people want to get green cards, they need to have health care. That was also an executive action. And then this executive order about state-local cooperation on refugee resettlement. That was also done through executive action from the president. So maybe the impact might not be nearly as extensive as some people were making it out to be, but it can still have a pretty significant impact on their border approach.
Yeah, and I think the other thing to recognize is that a lot of other policy changes have been about the legal immigration system and how USCIS processes legal applications, such as changes to the H-1B process, the standard of review for H-1B extensions, things about when people are eligible to apply for work authorization, the student visa rule, and when students can fall out of status. These may be implicated, again, depending on the timing and how many of these things Cuccinelli was responsible for and are in writing. That's another thing that the judge noted, is that under the Federal Vacancies Reform Act, only written policies can be challenged. So, remains to be seen. It does open the door to potentially more litigation over things. The administration is appealing this, is planning to appeal this, but as of this recording, 3 days after this decision, Mr. Cuccinelli is still listed as acting USCIS director and acting deputy secretary.
And he likes to tweet a lot. And once again, as of the date of this recording, the time and the hour, he has not commented on this issue on Twitter, and there's been crickets.
All right, Cris, Theresa, that's as good a place as any to leave it. Thanks as always for joining me. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. I'm Jordan LaPier. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Cris Ramón and myself and produced by Cris Ramón, Yafet Tawahara, and me. Our editor is Yafet Tawahara, and the executive producer of BPC Podcasts is Ashley Swearingen. That's all for now. Join us again next time on This Week in Immigration.